Welcome back to the Law News Network. What you just watched was the reading of the verdict of the State versus Frank Bybee matter. Once again, he was found guilty of kidnapping, exploitation of an elderly person. He was found guilty of 3 computer crimes and 8 counts of fraudulent use of a personal identification. Now, it must be said that even though he was not found guilty of attempted murder, he still faces a chance to serve a life sentence. This remains to be seen. We'll see what happens when we do cover the sentencing, which will come at a later date, as you heard previously from the judge. That date has not yet been set, but as soon as we are made aware of that date, we'll be sure to bring you the live coverage if we can, so that we can complete this trial, just so that we know exactly what Frank Bybee, who was once previously a sheriff's officer, an individual who was commissioned to serve the public, who has now been found guilty of kidnapping and exploitation of an elderly woman, particularly in this case, victim Marcia Soul. So what we're going to do now is we're going to transition over into the Slenderman case. If you recall, the Slenderman case was Wisconsin versus Anissa Weir. And in that case, it was a really bizarre case in which there were 2 children, 2 minor children by the name of Anissa Weir and Morgan Geyser, who stabbed one of their classmates by the name of Peyton Leutner 19 times, and miraculously Peyton survived those stab wounds. Now, what we know from the defense was that both girls claimed that they committed these acts due to the fact that they needed to kind of subdue this individual by the name of the Slenderman so that he would not come after their family. So we have with us today, we have Lawanda Hodges, who is a former prosecutor and currently a criminal defense attorney. Lawanda, thank you so much for being with us this morning. How are you?
Hi, I'm well. Thanks for having me, Stephanie.
Oh, of course, it's our pleasure. And we know that you're a former prosecutor, so what I'd like for you to discuss with us, with your expertise, is talk to us a little bit about pleading or moving forward with trial with the stance of pleading not guilty by reason of mental disease or defect. Talk to our viewers a little bit about that and explain that to us if you can.
Absolutely, Stephanie. As a basic premise, a person needs to be competent in order to stand trial.
Right.
And what that essentially means is that you have to be able to effectively assist your attorney in your presentation of your case. You have to effectively be able to confront your witnesses. So if they are testifying against you, you want to assist your attorney in their cross-examination. All of these has to deal with competency. And so that's just a basic premise. And so when someone says they're not guilty by reason of mental defect, they're saying that they are not competent to do those things. And of course, before that determination is made by the court, the defendant has to actually go through an evaluation. And once that is done, if they determine that this person is not competent, they can plead that they are not guilty because they're not competent. And that essentially means that they cannot be held responsible for their actions because they just did not know what they were doing. And moreover, they cannot effectively assist their attorney during the trial to put up a robust defense,
right,
because they don't know what they were doing and they don't know what they're currently doing.
Right. So, well, in this case, we know for sure that Anissa Weir was competent to stand trial. However, when it was returned back from the jurors, we found out that they found that she was not guilty due to not being able to understand her criminal wrongdoing because of her mental disease or defect. Now, talk to us a little bit about what kind of a tactic, or why would a prosecutor not want to proceed forward with trying the case of her co-defendant by the name of Miss Geyser, Morgan Geyser? Why do you think they went ahead and reached a plea agreement? The plea agreement was not guilty by reason of mental disease or defect. Do you think that this was to save maybe some time, or do you think that maybe they thought that they would have had the same verdict again?
It could be either of those things, Stephanie. Quite frankly, as a former prosecutor, I had to make that very difficult determination. This could be a case where the co-defendant, who is the co-conspirator, is not able to testify against this co-defendant, it also can be a determination that they understand that the jurors will feel empathy or sympathy towards the co-defendant, particularly because of the age. But those are all determinations that the prosecutor has to determine, sometimes before trial, sometimes in the midst of trial. Mm-hmm. And one of the things you're thinking of is, if my ultimate goal is to make sure that justice is served, and that could be by way of a plea agreement or by trial, a bird in the hand is always better, right?
Right.
And so if you have a plea, and it's a reasonable plea, and all the boxes are checked and everybody is satisfied, justice is served, this person is going to be handled effectively by the judicial system, then you take the plea. Right. Because, trial is risky.
Absolutely. Trials are very risky, and you never know what can happen, especially when a trial is left in the hands of a jury or even a judge. Even if it moves forward with a bench trial, I've had some experiences where I've been surprised by the ruling of a judge. What I want to discuss further with you is the fact that I believe it was Anissa, as part of her agreement, she was sent to a mental hospital in lieu of prison, but she has to serve at least 3 years at the hospital. What will happen once those 3 years are up? Will she have to be reevaluated once again in order to determine that she's not harmful to the public? Or what will have to happen after those 3 years are up?
Okay, so Stephanie, after those 3 years are done, the court will make a determination whether or not she's competent to then. In many jurisdictions, you're sent away to become competent, and then once you're determined to be competent, then your charges are pressed against you to go forward, and a determination can be made about your ability to stand trial and to subsequently be sentenced. So after the 3 years in, the court would then determine whether or not she's competent. And if she is competent, then the trial can go forward. Or if she's not competent, she will remain there until her sentence is completed.
Okay, and so we know as of this point right now, she's a minor. She's only 15 years old. By the time that this sentence, the 3 years in the mental hospital, is up, she'll be a majority. She'll be 18 years old at the time. Will that affect the procedure that will have to take place afterwards, or will it remain essentially the same?
It should remain essentially the same. It may vary per jurisdiction, but it should remain essentially the same because it is at the time of the crime.
Okay.
She was at the time of the crime.
Okay. So what we're going to do is we're going to play a clip of the beginning of the trial for our viewers who are unable to watch the Slenderman case. So we're going to take it back to the very beginning, and we're going to take a look at those clips, and then we'll talk a little bit about it once they're done.
And while you were teaching 4th grade, did you get a chance to have a student by the name of Anissa in your class?
I did.
And is that the Anissa that's sitting at the table?
It is.
Okay. And what grades did you teach Anissa?
It was 4th grade and 5th grade. So we kind of did a loop where we had them for 2 years.
Okay. And let me ask you this. How would you describe her as a student?
I had Anissa mainly for reading. And so what I found is that Anissa often connected with texts that we read. She would participate with questions. So for instance, if I asked text-dependent questions, things that happened within the text, she was very attentive and could answer them. Okay. She would participate when it came to me directing things. But when it came to do partner work and things like that, I kind of had to push her a little bit with that.
Okay. When you were teaching her, did you ever note any issue with her in terms of focus?
A little bit when it came time to independent reading time. We kind of like kids to have this nice stretch of time where they actually have eyes on text so they can practice reading strategies and things like that. And sometimes Anissa would maybe ask to go to the bathroom, or maybe she'd have to visit the classroom library to get a book or something along those lines, where I'd have to be like, we need to do independent reading.
And did you ever at any point notice any delays in her interpreting and analyzing literature?
She has a really good, how can I say this, text dependent. So when there were really like surface level questions, she was really good at that, and she could make connections to her own life with that. But when it came to kind of analyzing the text or inferring a little bit more, she was challenged in that area from what I remember.
Okay. And what about her ability to have relationships with the other peers in the classroom? What was that like for her?
So I mainly had Anissa for reading time. So there were two teachers. So there was Mr. Haynes, who taught like math. He was kind of like her homeroom teacher, teaching math and science and things like that. So I had her mainly for reading. And so there was a lot of partner work during our time where kids would have to turn and talk and maybe discuss a question or discuss the text or engage in some kind of project. And oftentimes she would kind of not really want to engage in that process. Like there wasn't a partner that she would reach out to and say, hey, Mrs. Reinders wants us to turn and talk about this, let's chat. She didn't really have that. She would kind of, flail, like go through her book, or she would sharpen her pencil, hoping that enough time would pass that she wouldn't have to engage in that. So what I ended up doing a lot of the time was I would assign her a partner. So I would do that with all the kids, so not to like alienate her. It would be like I would assign partners for everybody that way.
Okay. So you did notice that there was some difficulty on her part getting along with some of the peers in her classroom.
Sustained.
Yeah. Okay.
Oh, wait, I sustain the objections. That gives Attorney Smith time to rephrase it if you'd like.
Did you notice anything about her ability to get along with her peers?
During reading time, I think she just was kind of isolated. She didn't go out of her way to do like the turn and talks and things like that. She wasn't social in that regard.
Okay. But let me ask you this. Was she at all mean to the other students?
No, I never saw that.
Was she ever disruptive in the classroom setting?
No.
Was there ever a point where you became made aware that her parents were going through a divorce?
Yes, so I believe her parents came to talk with Mr. Haynes. Mom or dad came to talk to Mr. Haynes before, I want to say it was the summer before 5th grade. Like it was just in our back to school days in August, where mom and dad had mentioned that Anissa was a little emotional because they were thinking of separating or divorcing. I don't remember which one it was. That's kind of our way of being attentive to the needs of the student, because a big part of teaching is not just the academics, but it's the social emotional. And so it was kind of like, keep an eye out for Anissa. She's kind of having a difficult time with this. So it's just kind of being aware of that.
Okay. And let me ask you this. Was there ever any points that you observed Anissa appearing to be emotional or crying?
Yeah.
How many times did you recall you that?
So for instance, she would come into my class, she would come into reading class, and you could tell that she had been crying or had been upset. A lot of, maybe there was like an issue on the playground, and then reading would be after recess time. So maybe something happened on the playground or something along those lines. So then she would come in, still looking visibly upset from that. Usually Mr. Haynes would kind of process and debrief with her a little bit and then send her to me.
Okay, but you never directly yourself talked to her about what was causing her to feel that way?
No, but I would check up on her and say, what can I do to help? Or, hey, we're going to do this today, and I know you're going to do a great job, to try to get her to focus academically.
Welcome back to the Law News Network. What you just saw was testimony from Anissa Ware's 4th grade teacher by the name of Christine Reinders. And she was basically providing us with some background on Anissa, allowing the members of the jury to get to know her a little bit, and a little bit as to how she was during the academic school year. We still have Lawanda with us, thankfully. We still have Lawanda with us. And so, Lawanda, what I want to do is just talk about, excuse me, this testimony that was elicited from Christine Reinders, who is Anissa's, or who was, excuse me, Anissa's fourth grade teacher. And what struck me as odd is during this testimony, we're receiving a lot of character evidence on the defendant, which normally we don't see, or normally it would be objected to. Talk to our viewers a little bit about instances in which the character of the defendant would be admissible during trial.
Well, of course, Stephanie. So sometimes, from a strategic perspective, the defense attorney wants to bring the character into question. But there are pros and cons in doing that.
Right.
So if you open the door, is what they say. If you open a door into the defendant's character, the prosecutor is able to walk through that door and refute or debunk that character by, for instance, other witnesses who are going to say things about the character witnesses, for instance. The other witnesses can say that they would not believe the truthfulness of the character witnesses themselves. The other witnesses can talk about the defendant's character, which is always very interesting. You never know what you're going to get. But also, the prosecutor can cross-examine these character witnesses by asking them about specific instances of conduct.
Right.
So, for instance, the witnesses, the fourth grade teacher can talk about all these great things about the defendant, and then the prosecutor can cross-examine that fourth grade teacher and say, well, do you know that she also did these things? Do you know about X? Do you know about Y? And those things can be incredibly harmful to the defendant.
Right, absolutely. I agree with you there. The thing is, with the testimony that was elicited, I would have the feeling, or I have the feeling, that it probably would have elicited some emotional, I guess, pulls from the members of the jury, only because they were talking about her ability to have relationships with others in the classroom, and demonstrating that this started way back when she was in fourth grade, that she kind of kept to herself. Her fourth grade teacher was informing the members of the jury that during the time when they would have peer-to-peer partnership, when they would have to read together in class, that she would kind of do different activities such as sharpening her pencil in order to avoid having to, I guess, conduct with other individuals in her class. One point that was made, however, was that she never showed any signs of being disruptive or being mean to other individuals in the classroom. What do you think that particular point, the fact that she was not necessarily mean or disruptive to individuals in the classroom, do you think that testimony maybe helped or did not help the defense in this case?
Yes, I think that it absolutely helped the defendant, because the argument is that she is detached, right? So it's not a malignant heart, someone being malicious, trying to kill someone. It is detached from reality. And so if she had been showing signs ever since the fourth grade, where she's not being cruel, she's not being malicious, but she is just detached. She has a disconnect with her peers and arguably reality as she grew up.
Hello?
Yes.
Oh, okay. I'm sorry. I thought I lost you there for a second.
Nope. I ended abruptly.
No worries. No, but I really have to agree with you there. I think that we're both using our I'm a former prosecutor as well, so we're both thinking as criminal defense attorneys that yes, that statement right there would absolutely help out Anissa's case some more. So what we're going to do is we're going to throw to another clip. We're going to throw to the lieutenant from the Sheriff's Department, and then we'll talk about his testimony when we get back.
Were you involved in any way in the investigation of stabbing on Big Bend Road in Waukesha on that day?
I was.
And what was your role that day?
I responded to the initial scene of the incident to assist the city of Waukesha. I coordinated a perimeter with their officers, handled some media inquiries, and then I cleared that initial scene.
Did you do anything else after that?
After that, I resumed normal patrol until a phone call that the dispatch center received later that afternoon.
Okay. And all of your investigation that day and your role in the investigation that day, did you prepare a report regarding
I
your
did.
involvement?
I did.
Okay. And at the time you prepared that report, it would have been like maybe the same day or the day after you were involved in the investigation?
Correct.
And so you prepared that report when things were fresh in your mind?
Correct.
Okay. On May 31st, 2014, were you involved in the apprehension of the suspects in the stabbing?
Yes.
And were you present when those suspects were actually taken into custody?
I was.
And who did you assist in the taking into custody of, if anyone?
Anissa.
And did you give her any commands when you made contact with her?
I did.
And did she cooperate with commands that you gave her?
She was extremely cooperative.
Did she struggle with you in any type of way?
Not at all.
Okay. Did you notice anything about her emotional state at the time that you had contact with her?
I did. I noticed she seemed very scared, upset.
Okay, and did you notice anything about her own physical appearance at the time?
I noticed that she was wearing a blue sweatshirt and it had some dark stains on the front.
And did you then ask her if she was injured?
I did.
And what was her response?
Her response was no, that she was very scared.
Okay, and did you ask her why?
I did. I asked her, I confirmed with her a second time that she wasn't injured because of the staining on the shirt. And she said, if I told you, you wouldn't believe me.
Okay.
Or something to that effect, or you would think I'm crazy if I told you, something to that effect.
Okay, and then what did you say to her?
I told her that I didn't believe she was crazy.
And what was her response to you after you said that to her?
I believe after I said that, she made the comment, some bad people were going to do something, or somebody was going to do something to my family unless I did something bad. I read that paragraph.
And does that refresh your recollection of what she said about the people that she thought was going to harm her?
Yes.
And what did she say about the people that she thought were going to harm her?
On that day, she said, some people were going to kill my family unless I did something very bad.
I don't have any other questions.
All right, thank you. Cross-examination.
Just a couple of questions. Lieutenant, the girls, when you first made contact with them, is it fair to say they were very cooperative?
Extremely cooperative.
Seemed to understand your role and acquiesce to your authority?
They did. They listened very well.
Is there anything, and I'm not talking now about the blood or the crime that they were alleged to have committed, but was there anything unusual about the way they were acting in terms of, did they not seem to understand where they were or what they were doing?
No, they seemed very aware, and they just seemed like normal girls.
Now, you just repeated a statement about Anissa stating that some people are going to kill her family unless she did something very bad. Is it fair to say that that statement was made to you many hours after the alleged crime had already occurred?
Well, I initially had contact with them when I took them into custody at around 2:24 p.m. The initial incident was reported, I believe, around 9:55 a.m.
If I'm doing my math correctly, we're talking about like 4.5 hours later when you took that statement?
Yes.
Nothing further.
All right, any regret?
Just a few more questions. I know you had contact with her maybe quite a few hours after the stabbing on Big Bend Road, correct?
Correct, around 2:24.
Around the time that you had contact with her, she appeared still to be very emotional distraught, correct?
Yes. She appeared scared to me.
I don't have any other.
Welcome back to the Law News Network. Who we just heard from was the lieutenant who apprehended Anissa on the date of the incident in question. He did inform us through his testimony that he gave commands and that Anissa was very cooperative. However, he provided some statements from her. And I think that it's very important that we bring Lawanda back in so that she can talk to us a little bit about statements that were given by the defendant. So here we had the lieutenant who testified as to statements that were made by Anissa at the time that she was apprehended. Lawanda, if you can, for our viewers, explain to us why these statements were considered admissible, because we know that statements made outside of court to prove the matter asserted are considered hearsay. So explain to our viewers why these statements, which were made out of court, necessarily would not be hearsay in this case.
Absolutely, Stephanie. So we have hearsay, like you said, which are statements made out of court to prove the truth of the matter asserted, to go to the truth of the case, right? Those are hearsay.
Right.
But there's also a category called non-hearsay, and it means exactly as the name depicts, that it's not hearsay. In other words, statements that, although are made outside of the courthouse, could be admissible if they have certain degrees of reliability. Here, we have a statement from the defendant, which is considered an admission. And so the prosecutor would bring these statements in, the prosecutor being the party opponent,
Right.
would bring the statements in as a party opponent because these are deemed admissions by the defendant.
Right.
And they are reasoned to be reliable because they were made by the defendant, number one, but also they were made very immediate or very closely connected to the time of the crime. And then also there are certain other legal parameters that go into it, like the defendant having to have been Mirandized by the police officer.
Right.
And that just means being notified of all her rights, the right to remain silent, the right to have an attorney, just to make sure that the statement is voluntarily and freely given. So assuming all those things were made, the Miranda was done, the statement was considered voluntarily given, then it is an admission and therefore non-hearsay. And although made outside of court, is considered to be reliable under 801D. I can go into the rules of evidence, but they're considered to be reliable and therefore not hearsay.
Right. Great explanation for our viewers. Now, why, in this case, we know that Anissa is still a minor. She's 15 years old right now. So why do you think that it would have been proper, or would it have been okay for the police officers in this case to talk to her without an adult being there with her? We know that they were apprehending her at the time that they received the statements, particularly the statement that I'm referring to is she stated, "If I told you, you would think I'm crazy," when the lieutenant asked her what happened. So do you think that these statements that were elicited from her during the time that she was apprehended, should an adult have been there with her?
You know, Stephanie, that's a really great question. And I'll tell you what, I think that there are two schools of thoughts. And so, of course, you want that immediate statement that is made at the time of arrest once you're being Mirandized, because the argument, it goes to your mental state.
Right.
But with this being a juvenile, you know, I think that it would not have been a bad idea to have the parent available to ensure that the statements were voluntarily and freely given. Because there is still that analysis that has to be made. So just because a police officer gets a statement, that doesn't mean the statement would be admissible in court, right? And even if the statement is not suppressed because it's deemed to be voluntarily and freely given, there is still a jury instruction that has to be given to the jury for them to make the determination whether or not it was a voluntary statement.
Right.
And so part of that analysis, I would submit, has to do with whether or not she was able to give a statement without her parents being available or being accessible. Right? That's the argument. And then when the trier of fact hears that information, they can take that in consideration. I say all that to say this. It's very tricky when a police officer asks me, when I was a former prosecutor, when they would ask me for my advice, I would have erred on the side of caution. Right? But that doesn't mean that that's the correct move. That just means that that's a more conservative move because I'm looking forward to trial. right? I'm looking at what's going to happen, even if we get past a motion to suppress. How is the jury going to perceive the officer's conduct? And they might hold it against the officer and the prosecution.
No, I have to agree with you there. Sometimes it's better to err on the side of caution or to be conservative, as you said, just so that we're sure that all our I's and our T's are crossed, so that we can ensure that these statements or the particular evidence that we need to come in actually comes in, because sometimes it makes it harder for the state to have to prove their case beyond a reasonable doubt when we know behind the scenes that we have all the evidence that we need, but because sometimes it was obtained in an improper manner, there's nothing that we can do with it because it would be deemed admissible. So I tend to agree with you there that I would, as a former prosecutor myself, I would err on the side of caution and probably think it would be best to have, especially because she was so young, to err on the side of caution and have her parent or an adult there with her, just to ensure that the statements were given voluntarily. Now, we have right out the bat a statement from Anissa stating that the reason, I guess, explaining to the lieutenant that she had to do something bad. If she didn't do something bad, that something bad was going to happen to her family. Now, we're receiving this statement right off the bat, right in the beginning of trial, and it's leading us right into, in my opinion, this mental disease or defect claim that the defense is making. What are you thinking about that statement that's coming out? And that came out during direct examination.
So it came out during direct examination in the state's case in chief?
Yes.
I think that the state is just strategically trying to put everything out there because, of course, you want to win the jury at the very onset. You want to do it, voir dire, and you want to keep it, right? And so it's important for the prosecution to appear trustworthy and not try to keep anything back. And so I think this is the prosecution's way of owning what they anticipate the defense is going to be. Like, yeah, she made this statement. That's number one. So I want to put that out there. Jury knows, and you heard it from me, the prosecutor. That's number one. Number two, it also could be a lot more strategic on the prosecutor to do that, because the prosecutor wants to show the mental state and the intent of the defendant at the time she was arrested. That this is intentional and it's methodical. And it's so methodical that as soon as you arrest me, I'm already putting my defense forward saying, oh, you're not going to believe me. Like I was doing this because my family might be injured, right? So you're doing it because you want to go ahead and set it up that I'm not competent. Strategic. I want to set it up. And that just means that there's a lot more methodical, and if we're trying to get away from that whole, malignant heart, a depraved heart, somebody who is intentionally trying to kill, the prosecution might want to show that the defendant is actually very methodical in doing this. Right.
What I want to go to next is we're going to go to Detective Thomas Casey, and through his testimony, the notebook of Morgan Geyser was brought into evidence, and they were going through her drawings, and she had some strange type of drawings in her notebook. Explain to our viewers exactly how important it is, and I'm talking generally, how important it is to actually have, and I don't want to call it demonstrative evidence because this is not, but to have physical evidence demonstrating for the members of the jury exactly what came from the actual defendants in this case. So as I stated, we have Morgan Geyser's notebook that was found in her locker, and we have Detective Thomas Casey, who is going to provide testimony as to the strange drawings that were found. So tell me, how important is that, having physical evidence in a courtroom? How important would that have been in showing it to the members of the jury?
Very important, Stephanie. The reality is, jurors are just like anybody else, and the judges as well, right? And so some people listen, and that's how they learn. by just orally, right? And
Right.
other people are visually. And so it's always good to have both because, you know, you can hear testimony, but it's a different way if you actually see testimony. And I say testimony because this physical evidence is like a written testimony.
Right.
The physical evidence speaks for itself as well, just as well as the witness that's on the stand. And so you want to have both. So it's one thing to say that, okay, she might not have been competent or she might have had a mental defect. And it's another way to show it. Say, like, this is physical evidence. These are the things that she actually drew. It shows her state of mind during this time period. And it is just powerful as oral testimony.
Great. So what we're going to do is we're going to actually go through to that clip right now of Detective Thomas Casey, and then we'll talk about his testimony when we get back.
I'm showing you both a sealed plastic container, including what is noted as item 6, sorry, that kind of day, item 56.
Correct.
Can you tell me what that is?
It's a black notebook that's spiral bound. It was taken from the locker of Anissa Wire at school.
And it is her Spanish notebook, correct? Also in front of you is Exhibit G. Can you tell me what that is? In your hands.
This? That's
Yes.
G? Isn't this this is a photocopy of item number 56?
Correct.
What was the first exhibit that he was handed?
He has
The exhibit
number
number?
56 from the police department.
That's Exhibit G.
Correct. Exhibit G is a photocopy that we made of the,
Of item 56.
correct.
All right. And there's nothing magic about it, is there?
I hope not.
No, okay.
No.
So 56 is G. A copy of...
A copy of 56.
So let's just
However,
be clear. Exhibit G is a copy of item 56, true?
True.
All right.
now there's one difference between item 56, and we looked at it together during the evidence view, and Exhibit G. A number of blank pages were removed. Am I correct in that description?
I believe there's a number difference, yes.
Okay. Does anything in item G strike you as not being included from number 56?
Not that I know of.
Okay. So you recognize that as the notebook that was taken from Anissa Wire's locker?
Yes.
And it's a Spanish notebook, correct?
Yes.
At the end of the notebook, about 3 or 4 pages in, what do you find?
You talking about the drawing that you fill out on the front or
No.
a different one? Different one? The third page, it says March 13, theme concert, We Are the Young, 71, We Are the Future, Tomorrow, 54, Seize the Moment, 71, Simple Song of Peace, 65.
And after that?
The next page.
Yes, sir.
Some scribbling, not, could be a bird upside down, and I guess it's a bird upside down.
And after that?
After that, back in the notebook.
Okay. Detective, why don't you look through and see if you recognize the phrase "always watching" or "always watches" within that.
Sorry, Ms. McMahon, are we still in Exhibit G?
Yes?
Okay.
Okay, it looks like there's something written that appears to be that more in the middle of the notebook.
And after that, is there a picture of a faceless man?
There's one blank page that's in between.
So in the back of the notebook, not to the end of the notebook, but on the inner pages, there's "always watches," correct?
Correct.
And there's a faceless man with a tie.
Yes.
Did you, in your investigation, come to learn what the phrase "always watching" or "always watches" refers to?
No.
Okay. Okay. Never heard that that was a reference to Slender Man.
I mean, I know that they say that he always watches, but where the exact phrase came from, or that it's keyed or coined just as that, I don't know that.
Okay. So in the back of the notebook, not all the way to the end, but within the inner pages, surrounded by blank pages, you have always watches and a faceless man with a tie, correct?
Correct.
You also recovered the department recovered a number of notebooks from Ms. Geiser, correct?
Correct.
Showing you what's been marked as Exhibit H and asking you if that is a copy of item 61, Morgan Science Notebook.
It appears so.
And within Ms. Geiser's science notebook, were there a number of pictures?
Yes.
And how many of them did you have an opportunity to review?
Right now, you want me to count them? One.
I'm sorry, this is Exhibit H?
Yes.
It's a composition book that says TAPS on the front, and then it says Science, item number 61.
I don't have a copy of that, I'm sorry.
Apologize, Your Honor. I believed that everyone did. The court also has a copy. Your Honor, I apologize. May we have a brief recess to make sure that the state has all the copies they need?
Well, they only need one right now, right?
Okay.
And all they need is H.
These are the science note. This is the science notebook that was provided in the disc from the DA's office. You've had an opportunity to review it?
Yes, I have.
And does it meet with your recollection of what was contained in that document?
I believe that it is.
And do you feel the need to open the exhibit to determine whether or not it's accurate?
No. I trust you.
Thank you.
Welcome back to the Law News Network. And whom we just heard from was Detective Thomas Casey. Detective Thomas Casey was testifying regarding the notebook that was found in Morgan Geier's locker. They started to go over the strange drawings that were found in her notebook. And we still have Lawanda here with us. Lawanda, thanks so much. I know that we only have you for a few more minutes, so I just want to get some more of your expertise, just a little bit from you this morning. So what we had here is that the prosecutor began to go through the, the drawings that were found in a notebook, or copies was found in Geier's notebook. And one of the things that she asked the detective about was there was a phrase in the notebook that stated always watching or always watches. Now, to me, this is a statement by a co-defendant, and she was attempting to elicit this statement to come in. Me, I'm putting on my criminal defense attorney hat, and I'm saying I would object to that statement coming in, because to me that's a statement that you're making for the defendant, because there's this notebook that we have, and I can't cross-examine this notebook. So talk to us a little bit about this particular statement, the statement that was found inside of the notebook inside of Morgan Geier's notebook.
Okay, so to be clear, the statement is from a co-defendant, but not the person who's actually at trial.
Correct.
Okay. So, of course, as a defense attorney, I would object, and I understand what the state is trying to do. Mm-hmm. The state is trying to bring it in as a co-conspirator statement, right? Which would be non-hearsay, and it would be considered non-hearsay under 801D, a co-conspirator statement. But the objection that the defense attorney has to make is that, one, they haven't established that this is, in fact, a co-conspirator statement, because they haven't established that there was a conspiracy, right? And they haven't established that the statement was made during the pendency of the conspiracy.
Right,
Like those
on
are the
point.
arguments. But also, like you said, you can't cross-examine. You can't cross-examine the notebook. I mean,
Right.
that is the hard part about a co-conspirator statement
Right.
because it comes in and it's not an issue, a confrontation. It's an admission that you all, as a defense attorney have to deal with. But I think what you do is you try to dismantle it as a co-conspirator statement under the rules and just say, well, there's not, it hasn't been established that there is in fact a conspiracy and that co-conspirator isn't here to attest to that fact. And then that there's no guarantee that while that alleged conspiracy was going on, the statement was made. But that's a hard one. That's a hard one.
It is, and I'm sorry. Sorry, but I had to ask because, I mean, this was, I'm getting a little nerdy here, but I love the law, and this is something that, we find, a lot especially in the criminal practice, we find that there are times that, we have to find ways to get around, procedure. We have to find a way to get around procedure, and essentially in this case the prosecution was able to do it because they were able to get in that testimony, even though the detective in this case stated that he was not aware of the statement and he did not know what the statement was. But at the end of the day, the members of the jury still heard that statement regardless of the fact. And maybe it's not considered, I guess, testimonial evidence, but that's something that could still be in the back of the members of the jury's mind. Do you agree?
I do agree,
Right.
and I'm wondering, as I hear it, that maybe the defense attorney should try to see if they can get some kind of curative instruction explaining to the jury what's testimony and what
Right.
isn't. And but the reality is, we know those curative instructions come out, and the jury they can't unhear what they've heard. And so, and then when you object too much, it just seems like you're trying to hide something,
Right.
and they hold that against you. And so it's an interesting conundrum. And quite frankly, I think that the judge is probably just going to say, well, the jury can give it whatever weight they want to give it to. Give it. You have a right to cross-examine about this statement and ask the detective all those things. But were you there when the statement was given? Do you know why the statement was given? Do you know what the statement was about? Do you know anything? All you know is there's a statement, and here they are making these generalizations of what they're about.
Right.
And hopefully, at least one person on the jury believe your position and go with it, and they take it back during deliberations. But ultimately, the jury is going to give it whatever weight they deem they need to give it. And you just have to hope that they're fighting for the defense as a defense attorney. That's what you have to hope.
Right. There's always that hope, right? There's always
that
hope
hope
for that one. Well, Lawanda, thank you so much. Lawanda, I'm sorry. Thank you so much for being with us today. And, we welcome you back. This really was, I had a great time speaking with you this morning. And, I'd love to do it again.
Thank you, Stephanie.
Have a great day.
You too.
Thanks.